our speakers today are Dr. Sandra New, who has actually been a Summer Institute graduate and has done extraordinarily well. She is responsible for the supervision of nursing and care management for the National Accounts Division of Arkansas Blue Cross and Blue Shield. And she's been in that position for, about 7 months? And her goal in this position is to impact lives, maximize health, and manage costs as individuals navigate a complex healthcare delivery system that seems to get more complex by the day. She won the Chancellor's Teaching Award in May of 2014 and was chosen from a number of professors across 6 colleges here at UAMS. She earned her doctorate in nursing, from the University of Utah, and her Master's of Science from Arkansas State, and her bachelor's from UAMS. So you are an alumna. Mr. Douglas Jones is an attorney at law in elder law practice. He's been a frequent lecturer on business and trust law for professional groups across Arkansas. He has been in legal private practice since 1985 and is one of the founders and principal shareholder of the elder law practice of Douglas Jones and Cynthia Jones. He earned his JD degree from the University of Arkansas in Little Rock and an MBA from the University of Colorado at Boulder. And he has a bachelor's degree in business management from Arkansas State University. He's a member of the National Association of Elder Law Attorneys, Elder Council, and several other professional associations. Neither of our speakers have personal business or financial content of interest to disclose, and I am going to introduce Dr. New to you, and we will move ahead.
We probably have all been impacted by people in our lives who have Alzheimer's, either someone you know, someone in your family, someone that you have been associated with in some manner. So this is very important content. And to start us off, I want us to think about it from a personal perspective. I have a colleague that I work with at Arkansas Blue Cross named Sheila Bullock, who is going to share a little bit of information about this woman on this first slide. This is actually her mother. And Sheila, if you would tell us a little bit about your story as a case presentation, please.
Hi, I'm happy to be here today and talk a little bit about the personal side of Alzheimer's. My mom is 87 years old. You see her here in her pictures with her granddaughters, and she is a patient at the Reynolds Center and was diagnosed with Alzheimer's 8.5 years ago. It has been a long, difficult journey, but we have been very blessed because she's doing very well. I'm very grateful to the Reynolds Center and the care that they give to her. We have physicians that come to our home. I don't have to bring her to the clinic anymore. I am blessed and fortunate that I am a registered nurse care manager by profession, and I've done that for many years. So I've had a lot of patients that had dementia. So I knew the logical part of it. I knew what was going to happen, and I knew what resources were available to me, because that's a lot of what case managers do, or try to find resources for these types of patients. But I did not know the personal and emotional side. And so I kind of just, moved forward through all this process, and I could just, logically get everything in place. We had the doctor come to our house. We had Meals on Wheels. We had a housekeeper. We're blessed that she has a home in Hillcrest that she's been in for 60 years. It's right across the street from UAMS, so the clinic loves running by to see her. And so she's got her home. She's got enough financial resources to be comfortable. And like I said, we had Meals on Wheels, housekeeper, we have someone coming in to help us do the medication, and I'm especially blessed that I have 3 wonderful siblings, and we work really well together. Even under those best of circumstances, I cannot begin to tell you how difficult it is. And I think that the things that I was most not prepared for was, even though I thought I had my perfect case management plan in place, and as a nurse I was, just diligent about her medications and working with the staff here at the Reynolds Center, I did not expect the resistance that I would get from her as much. I mean, I know you read about it, but it's not the same as, you know, being there in person. And she fought us every step of the way. And she's a wonderful, sweet woman, but very independent. She managed a Hancock's fabric store for 25 years back in the days when I was a little girl, and a lot of women didn't even work. Very intelligent, very strong-willed. So we started off, she fought letting go of the finances, and then she fought letting go of the medications. That was a really tough thing between mother and nurse, you know, letting go of the medications. I got a lock box for the medications. I had to get a lock box for the front door because, you know, sometimes it takes her so long to get in and out of the house, and we had different caregivers coming in. And then one of the main things that she resisted is people coming into her house. She only wants her children to come, nobody else. And of course, this is difficult. We all work and have fairly demanding jobs, and it's very difficult for us to be there all the time. She has allowed us to have one person that comes in 4 days a week in the mornings and gives her her medication. I've worked with the doctors closely so that now she only has to have her medications once a day. That's huge. I can't even begin to tell you. I was almost turning cartwheels down the hallway the day that we got it to where it only had to be once a day, because for whatever reason, you know, that really does bother her. Dr. Nee's going to talk to you, they're going to talk to you both a little bit about, you know, HIPAA. And I wanted to talk about the personal side that I've seen in my mother, 87 years old, her generation, the stigma that's associated with Alzheimer's. I've heard her talk about in the past about someone losing their mind. And it's like it goes along with mental illness, and it's such a stigma, something to be ashamed of, a family secret. Still to this day, she doesn't want to talk about it. And her siblings are the same way. 3 of the 6 siblings have had Alzheimer's, and the other 3 don't want to talk about it, you know. So I try not to talk about it too much, but I think we all need to talk about it, including all their children. We don't know what's going to happen. The other personal thing that I'd like to say, what I think I will probably, at this point, take from this experience the most is to live in the moment and to enjoy the little things. Because almost every time I'm with her, that's what really hits me the most, because I'm at work, I've got 3 sons, 3 daughter-in-laws, 2 grandchildren. I'm going 90 miles an hour like all of us are all the time. And then I'll spend my afternoon with Mom, and maybe I'll put her in the car and we'll go to Maumelle Park and we'll sit at a picnic table right on the river. That's about the most, that she likes to do anymore. And we'll have a little picnic there, and she's just so in awe of what the water looks like, how blue the sky is, how green the grass is, every little thing. And even if we don't go out somewhere, she'll sit. Her world mostly consists now of sitting in her recliner in her den, looking out the patio door at the birds and the squirrels and the trees and the flowers, and I'll be busy running around, taking care of everything, making sure she's got all the supplies that she needs. And it will hit me that she's the one that knows what's really important. She's the one that knows what really matters, the small details of life.
Thank you for that. And we will move on into the other content now. So everyone probably is aware Alzheimer's disease was first found back in 1906 by a German physician who realized that it's progressive, degenerative, and that it's shrinking of the brain tissue and is associated with memory impairment. And about 5 million Americans suffer from this disease. A great many of them are over age 65, with a huge percentage of them being over age 85. And this is just a nice picture to be able to see a normal brain with what it would look like as the tissue actually shrinks. When you look at the age of diagnosis, it may occur between age 30 and 60, but the rate increases completely by the time a person ages to age 60, and then 1 out of 3 after age 85. A lot of people ask about the family inheritance traits and how much of it is genetic, especially when you hear a story like Sheila's, where 3 of the 6 siblings have demonstrated Alzheimer's, but only about 5% are truly traced to that. And so just because someone in your family has maybe a propensity for and a genetic link, there are a lot of other factors that we think contribute, and maybe your lifestyle and physical activity and things may actually influence whether you get the disease. You may not actually demonstrate it just based on genetics. Arkansas prevalence, if you look at this last year, you can see about 52,000 people with Alzheimer's, and in the age of 65 to 75, it's relatively low, 8,000. When you get to be, it triples when you get into the next decade, and you would think because so many more at age 85 and older have it, that number would be larger, but you have to remember there's still not as many people who live into those older years, 85 and beyond, so still 21,000 is large. As we look at the boomers and the aging of the population, we will project something like 11,000 here in Arkansas, on up to 67,000 totally in Arkansas by 2025. So it's a staggering number of people who have this disorder. The cost of it is very expensive, $214 billion this last year. Medicare absorbed the majority of those. This is information data that was taken from the Alzheimers.org website. And now I'm going to talk just a few minutes with you about HIPAA. HIPAA, when I was first asked to do this, I thought, okay, well, Health Insurance Portability and Accountability Act, that happened as a law, happened back in 1996. There were three main purposes, and you can see them listed there, to keep people, to have them have access to health care insurance, to protect the confidentiality of their data, and to control administrative costs. Those were the main things. I looked for something that would be fun to kick off this portion because, what can you do about HIPAA that's really fun? And the only joke that I found that I thought might be pretty good is, what's the effect of most HIPAA presentations? And it says hypnosis. And so I chuckled when I saw that. I thought, well, for this audience, that would be appropriate. Looking at it a little bit more in detail, if you look at HIPAA Title I, you'll see that a portion of that was affecting parity and availability of mental health, was a part of the intent of the HIPAA Act in 1996. Also, taking care of newborns and their mothers and protecting them also was a portion of that original legislation. And then a couple of years later, women's health and cancer rights were woven into the expectation and services of this HIPAA law. One other portion that was affected is COBRA, and under Title I, COBRA changes included extending for someone who becomes disabled during their first 60 days of COBRA, such that if the other carrier, the other service that they're going to get is not very effective, then they can stay with COBRA an extended 29 months. They would not be allowed to be terminated if a new plan had less coverage, and children either born or adopted somehow would also have beneficiary coverage, which those are things that were included in this HIPAA Title I. HIPAA Title II looks at more the electronic world in which we live. We are now in an age where you can copy it, scan it, PDF it, fax it. You can put it on a thumb drive, flash drive, email, text mail, tweet it out. I mean, things come and go in manners that we've never had to deal with before. Our technology is phenomenal, but we also have standards to protect people with all those electronic transactions, and privacy and security is very important. There are about 8 rights that individuals have when you look at HIPAA in detail. As an individual, I have the right to access copies of my personal health information, my PHI. I also have the right to amend them if I find they're inaccurate and not correct. They need to be amended within 60 days. I get a notice, and everywhere you go nowadays you're signing waivers and notices and about privacy and how things are protected. We have the right as individuals to access the accounting and any disclosures that are made to other people. For instance, if I'm going to send this information to another provider, then I should be able to tell you that and describe the rationale behind that, and to make sure then that it is only disclosed as necessary for the care of that individual. It needs to be complete, accurate, up to date, certainly not altered or destroyed. Needs to be protected in its physical safeguards and the technical administrative, and we need to exchange that PHI in an accountable manner with our business associates. So those are about, the most important principles behind it. When you look then further at the standards, they're very similar. There's 6 of them that really are the cornerstones. One is getting the individual's consent, and when you're speaking with someone who has Alzheimer's, there's a point at which they no longer have the ability to give their consent, and we become advocates for them. And some of that, Mr. Jones, our legal attorney, will present to you a little bit more about that. Transmission only for treatment and payment and health care as needed to operate. One standard also is for patients to be allowed access. They can request things to be amended, as was said in the previous slide. Also, a thing that's important is I can restrict my access. If I don't really want anyone else having access to this, I can seal it up and make it where that's not available to other people. Health plans must have instituted privacy policies, and privacy must be protected with any contract and any other business affiliation that one has. So those are some of the standards in dealing with HIPAA, no matter what a person's diagnosis would be. It's to mainly prevent unintended access, is to ensure confidentiality and integrity, and then the availability in cases where a person is not able to speak for themselves. We need to have that opportunity to be advocates for them. It's to protect against threats and hazards, any unnecessary disclosures, and certainly is ensured in the workforce compliance all over the country. There is a particular regulation, 45 CFR, and it has part of it is in 160 and part in 164. These actually authorize the use and disclosure without written authorization. And within that, it may be for law enforcement purposes and situations, could be for public health, for controlling disease and surveillance of those disease, the ability to do investigations for the benefit of public health reasons and interventions. Some disclosures will require de-identification, and when I looked at that, I thought, of course, name and Social Security and birthday are the things that one immediately thinks of. But there's actually 17 items, and some of it includes your street address and your zip code, telephone number, fax number, email. I hadn't not even thought about the email, certainly Social Security and medical record. Gets into the other things like your beneficiary numbers of your health plans, account numbers, licenses if you have any, vehicle identifiers. Things that I had not really thought about. A full face photograph, you have to have permission in order to have a photograph used, or anything that would be comparable. Any kind of characteristic code or identifying number. So you can see to de-identify is quite challenging, but that in aggregate data is allowed to be shared when it is de-identified. Researchers still overwhelmingly believe that HIPAA privacy rule has had a negative impact on the scope, pace, and cost of research. And one of the other humorous things that I found about HIPAA said what HIPAA really stands for is highly intricate paperwork in abundant amounts. And I certainly have felt that from time to time as I've been involved with some research before, and that has been my experience, but definitely surrounding patients who have Alzheimer's and their families, that has been true. Anyone who's going to do research, it's important for there to be disclosure of the research protocol. No personal health information can be removed by the researcher, and it has to be that personal health information is necessary for the research purposes. There has to be documentation and a waiver from the internal review board who reviews what research is going to be done. And then documentation of that waiver, confirming that there's, no more than just a minimal risk of privacy to the individual. So that kind of wraps up what I wanted to cover about HIPAA. And the next portion of the presentation will be provided by Mr. Jones. And Mr. Jones is an attorney here in the Little Rock area who has been an attorney for quite a few years. He's been in practice since 1985. I think he was introduced earlier, but he is a member of the National Association of Elder Law Attorneys and an Elder Council and other related organizations, so I feel that he will have a great deal to add to the presentation today. So with that, I'll turn it over to Mr. Jones.
Thank you, Dr. New. It's also my pleasure to speak to this group today. And my wife and I practice elder law in Cabot, Arkansas. We work mainly with seniors and their families. And I know this presentation is going out primarily to a group of medical professionals in related areas. My intent is not to try to turn you into elder law attorneys, but just to educate you as to a few things to be aware of, to think about as you are talking to your patients. You know, when people come to us a lot of times, you may be the first professional that they have spoken to about the issue in their family. The intro slide, information for us boomers. I'm a boomer. My age, 58 years old, I'm a boomer. And us boomers have parents that are aging, have a lot of issues, and we don't know who to talk to. We don't even know what questions to ask sometimes. So we appreciate the opportunity to talk to different groups and explore a few different things so that when people come to you, your patients come to you and ask a few general questions, at least you know what directions to steer them in. So, okay, this is the elder care journey or the elder care continuum. And we all start over here on the left side of the continuum, a healthy, vigorous senior. And we're able to live home alone, we're okay, we can take care of our own needs, but as our health declines, we start moving to the right down the continuum. We have more aches and pains, medication, maybe we're home with a quote, well spouse, and that lasts for a while until the well spouse is not well anymore because they've been taking care of the sick spouse. And we've had many clients that's happened to. You know, the well spouse lifts the sick spouse and throws her back out or develops other ailments, and then they're both in the nursing home or both in the hospital. But as you move on down the continuum, declining senior with memory or mobility issues, initially for doctors or hospital, Medicare covers these costs most of the time. Some people in this area, in the middle part of the spectrum, are veterans, and VA may pay a portion of it. Some people have health insurance, or lucky enough to have long-term care insurance, but very few in my experience have long-term care insurance. So as they move on down the continuum and have more issues, more problems, well then usually facility care is required, assisted living or skilled care nursing, and that's usually funded. The primary payor of this care is Medicaid. And so if we have time, we're going to talk about that just briefly. First, I want to talk about a few documents that, regardless of how much money a person has, they need these four things. And Dr. New did a great job of talking about HIPAA, so I'm not going to spend a lot of time on that, except when someone comes in, we try to have them to sign a HIPAA authorization in advance just so they will have it. I know most hospitals and healthcare facilities have people sign HIPAA authorizations on the spot as they check in, but you know, maybe they're not able to. Maybe they've had a stroke and they come in and they can't sign anything, so it's good to have one in advance. This thing at the top, HCPOA, Healthcare Power of Attorney, is a document where you authorize whoever to make healthcare decisions for you if you can't make them yourself. If you haven't done this in advance, I say sometimes you forfeited your right to choose. You don't get to say because you didn't make that choice. And so who makes that decision for you? And that's a good question. I feel sorry for doctors and medical professionals sometimes because they're put in a position of having to give medical care to people that are not able to consent are not able to say what they want done, and there is no healthcare power of attorney. And it's a really difficult situation, particularly if there are family members in disagreement about what to do as regarding the care of a loved one. So it's important that you, if you're the one watching this, if you don't have a healthcare power of attorney, and a lot of you watching this will have parents still alive, if they don't have healthcare power of attorney, something to do. Private living will, and this is what we refer to sometimes as the pull the plug document. Private living will in Arkansas says, in general, if you're terminal or irreversible or permanently unconscious, that the attending physician, I'm paraphrasing here, has the right to withhold or withdraw treatment that only prolongs the process of dying. And this is something that if you don't have, you should have. A lot of hospitals have forms for private living wills that people sign on the spot, and they also have form healthcare powers of attorney that they have people to sign. And this is better than nothing, but a lot of times it's great if people can meet with an elder law attorney way in advance the time that they are sick, very sick a lot of times, and in a hospital, and be able to make these types of decisions with great clarity instead of having to make them at the last minute. Dr. New covered HIPAA. The last thing, property or financial power of attorney. Who do you want to make property decisions or financial decisions for you if you can't make them yourself? If you don't have one of these and you have to have someone make decisions for you, moving assets to pay your bills, selling property to pay your medical bills, doing whatever to help you qualify for Medicaid down the road to pay your nursing home expenses, then there's a problem. A lot of times, if you don't have one of these in place, a guardianship will be required. Just a couple of things I wanted to mention in general about powers of attorney. Danger signals. This doesn't mean that they're bad. It just means something to be aware of. If you see a one-page power of attorney, or which is usually a very, very old power of attorney, there may not be enough ink on the paper to cover all of the issues that need to be covered to authorize someone to take that action on your behalf. It seems like financial institutions and medical institutions are getting pickier and pickier these days. They're wanting to see on paper, did you specifically authorize your son or your daughter to make this decision for you that they're asking us to make? And if it's not specifically listed, then they may say no. And we've had that a lot of times with powers of attorney, even 25, 30-page powers of attorney that we have done, other law firms have done, that they look specifically at it. Does it specifically say that this can be done? So very old powers of attorney back in the 40s. Matter of fact, I saw a guy brought one in the other day, 1943, and it said something like, I authorize Sonny Boy to make any decisions for me that I could make myself if I was able to do it, Dad. That's about what it said. Is that good enough? Well, probably not. But that's all this guy had, and he lost capacity, and he can't go back and do it, so they had to go with what they've got. A very new power of attorney, just as bad sometimes. We always get these things after the fact, after it's too late to do something about it. We saw one couple of years ago where mom was declining, daughter knew she needed to do something, so she went home one evening, Googled power of attorney, and here's the top 25 results. She prints off number 1. Here, Mom, sign this. Mom signs it, and it wasn't, signed properly, witnessed properly, executed. None of that was done properly. And then Mom declined rapidly, and daughter needed to use it. So she started trying to use it, and nobody would accept it. That's when she came to us. Nobody will accept this thing. Well, no kidding, it wasn't done right, but it's too late. It's too late. So it's important, if you have a patient and it comes to your attention that they don't have any of these things, this would be a good time to steer them in the right direction. A power of attorney, I refer to it sometimes as a permission slip. You give another person the right to make decisions for you, business and financial decisions, but you still retain the power to make decisions on your own behalf. So it doesn't strip you of your rights. Just because you gave your son or daughter the power to make decisions for you, it doesn't strip you of your right to make your own decisions. So sometimes people say, you know, my worthless brother is stopping by mom's house every day and hitting her up for money, so I want a power of attorney for mom so that he won't be able to do that anymore. Well, if mom, even if she does a power of attorney, that's not going to stop him from doing that, or not going to stop mom from giving money to whoever she wants to give it to. Okay, so the power of attorney expires when you die, sometimes under the new Power of Attorney Act. In certain situations, it may continue for a short period of time to allow certain administrative duties to be taken care of, but normally when you die, it dies. And this is sort of obvious, but a lot of times people miss this. A power of attorney needs to be signed before someone loses mental capacity. I can't tell you the number of times people come in, bring mom or dad with them, and it's clear they're way past having any mental capacity. It's too late. It's too late. So, capacity considerations, and this could be a whole nother hour talk right here. Do you have capacity? Well, I'm not a doctor. I mean, I don't know. All I know is what the average person knows, what they observe when someone comes in. Do they appear to have capacity? Do they know where they're at, what they're doing, what they've got, and what they want to do? Who do they want to make decisions for them? And this other bullet point, undue influence or self-dealing, you've got to be very careful when you say who you want to make decisions for you, because whoever you name is it. And if you, when you name someone as your attorney in fact under a power of attorney, they step in your shoes, and whatever decisions they make for you, it's just like you made it yourself. It's your decision. And so if someone has to take someone like this to court, then one of the things that they raise sometimes is an issue of self-dealing. Did they use this money for their, say if you named one of your kids and they use this money for their benefit, could it be an issue of self-dealing? And sometimes it could. So there's a potential for abuse. Do you trust your attorney in fact? And this is just what I was talking about. All acts done by attorney in fact pursuant to a durable power of attorney, it's basically as if you did it yourself. Undue influence, any action taken by an attorney in fact resulting in the benefit to him or her will raise a rebuttable presumption of undue influence. So if dad has named daughter as his attorney in fact, and she takes dad's money and decides a good investment of dad's money would be a round-the-world cruise for her, that was probably self-dealing. You know, that's probably not the best use of dad's money. So if you haven't done a power of attorney, property power of attorney, healthcare power of attorney, and by the way, I do two. They can be together in one document. I do two separate documents because in Arkansas there's two separate bodies of law, one for property power of attorney, one for healthcare power of attorney. The financial or property power of attorney documents are usually sent to banks, brokers, financial professionals, where you know they need to see who has the authority to deal with mom or dad's money. The healthcare power of attorney goes to nursing homes, hospitals, medical clinics, who has the authority to make healthcare decisions. A lot of times these are not the same people. Mom or dad may not want Susie making healthcare decisions or property decisions, and Johnny vice versa. One may have a skill one way, one may have a skill the other way. So they need to pick who they want to make those specific decisions for them. So healthcare decision making for the competent individuals, I think we've talked about this. Living will, all referred in Arkansas as the Arkansas Rights of Terminally Ill or Permanently Unconscious Act. The ones that we usually do are pretty basic, where you appoint someone and the best thing to do for an individual is just for them to have a talk, eyeball to eyeball talk with one of their kids or whoever that they've charged with the duty of making decisions for them, especially when it comes to a life or death decision, to make sure that they're on the same page. You can have whatever you want written on paper, and that's critically important to have the right legal documentation in place, but it's also important for the parent to tell the child what they want, because a lot of this, and people in the medical arena know this, it's not clear sometimes. If someone has a stroke, like my mom, had a stroke and she was in the hospital for a long time, she was in a nursing home, she ultimately had hospice care. It's not daylight and dark is exactly what to do. So it's important to be philosophically in sync if you're the one charged with making decisions like, hey, what did mom want? What did dad want? So if you're the one making that decision, you can make it in peace. So the living will, a document that tells medical professionals and members of the family to what extent special means should be used or should not be used to keep your body alive if you're incurably ill or permanently unconscious. Beware of the documents with check boxes. Those can get you in trouble, hung by the tongue. If you say, I don't want this, I don't want that, I don't want this, I don't want that, it's hard to say, while you're sitting here today in good shape, what you may want or may not want, 5 years from now. That's the time. We've talked a little bit about healthcare power of attorney, where you appoint someone to make healthcare decisions for you. DNRs, most of you medical professionals are very familiar with that. In Arkansas, it's Arkansas Emergency Medical Services Do Not Resuscitate Act, where CPR can be refused by a patient by issuing or having their physician issue a DNR. There's some confusion about this sometimes. If a living will not prevent, like if you have a heart attack at home, if you have a living will with you, it's not enough. They're still going to resuscitate you unless you've also got a DNR. HIPAA, Dr. New talked about that. Here's just an interesting fact for medical professionals. Over 25% of validly executed documents are not honored. Why would you think this is the case? The biggest reasons given are fear of liability, obviously, and interference with physicians' professional actions. If there's as many as 2 kids, usually there's 3. 2's lived at home right by mama all these years, know exactly what she wants. One of them's lived out of state for years. The minute something happens to mom, I don't know if there's like waves in the air or what, but they're back. And then if you're the doctor and kid from out of state comes to you, gets right in front of you, and you say, if you touch my mama, I'm going to sue you, what are you going to do? I'm not touching your mama. So, with a 10-foot pole. So, that's why a lot of these, and this is a shame, that's why a lot of these validly executed documents are not honored sometimes. And there's also the perception that the directives question the physician's judgment of the patient's best interest. So, which, if you've been very, very ultra specific, I do want this, I don't want that, I could see how that would be the case. Because you said that, 5 years ago when you're sitting in some lawyer's office, and maybe the conditions are totally different now. Medicine's totally different now. The doctor says, hey, we could do this or that, and the private living will looks different, then that could be an issue. So, and this slide is dated. There may be another one now, but at the time there were only 2 states that had penalties for failure to comply with the living will. At that time, Utah and Arkansas. And if you're a physician and you don't want to do what is written in the living will, you have the right just to back out, and that's what you should do. You should back out and give someone else, another physician, the opportunity to to do what they want to do. So in the last couple of minutes, this is not medical information, but this is something I want you to be just vaguely aware of. So if you have someone that asks you, you can point them in the right direction. When someone goes to a nursing home or assisted living, how's it going to be paid for? Well, unfortunately, most of the time, it's private pay until they're totally out of money. And that's unfortunate. It doesn't have to be that way. I've seen situations where people just didn't know, and someone told them. We had a case a few years ago. The husband had early onset Alzheimer's. Someone at the beauty shop, that's a place to get your legal advice, someone at the beauty shop told this lady that she had to spend all of her money before her husband could get Medicaid to help pay his nursing home expenses. And that's what she did. She spent all of it. Now he's in a nursing home, he's getting Alzheimer's. She's broke and will be broke for the rest of her life. It didn't have to be that way. Some veterans are eligible for VA benefits, Medicaid, your home, your car, your prepaid funeral, $1,500 in cash value in life insurance, and household goods are exempt. Everything else counts. So for a single person, if they've got $100,000 and they didn't do other planning, there's other planning that can be done. In most cases, they'd have to spend down to $2,000 before they could get Medicaid to help pay nursing home expenses. If they're married, it's split up to a point. They had $100,000, $50,000 for dad, $50,000 for mom. If he goes in, his $50 spent down to $2. Again, there's other planning techniques that can be used to get them a substantially better result. But if they don't do anything, this is result a lot of times, or even worse, like the example I told you a minute ago. This lady didn't even know she could do this. She didn't even know she could split it. So she spent it all. And that's pretty sad. The state has the right to recoup on property after a person dies. So if mom's in a nursing home for a number of years, the state has the right to say, we paid $80,000 out in Medicaid benefits for mom's home. We want our money back. So we're going to put a lien on that house, and when it sells, we get paid first. They don't always do this. They have the right to do that. They can do that. But that's something that families need to be aware of. And this sustainability chart looks like it's a little bit cattywampus here, but this just shows first line, mom and dad may have $3,000 a month coming in. Their monthly cost of living is $2,450. They're okay. Second line, what if one of them has a health challenge? One of them has to have home care. Well, now their monthly cost of living goes up to $3,600, and now they're eating into their principal. They're not okay anymore. What if two of them have a health challenge? Well, now they can run out of money, you see down there at the bottom right, in 3.4 years. So it's important to do some planning while there's an opportunity to do so. It's important to do planning while you're still to the left side of the continuum as opposed to being to the right side of the continuum. That's all I've got. So are we open to questions? Or
Yes.
Okay.
We are. I was going to ask, and I think you pretty much answered it about loss of mental capacity. It is such a big glob. I mean, you've got the point where the doctor says no mental capacity. You've got the okay elder. There's this middle ground where you know that they're not right, they're not able to do their finances, but they've not been labeled anything.
Yeah, you'll have to repeat
In terms
that.
of that and how it plays into the power of attorney.
Okay, the question was about mental capacity and whether they may have capacity to sign a power of attorney, in the fact that it's not clear, and you're exactly right. In many instances, it's not clear at all. Especially in cases of early Alzheimer's, there's a lot of situations where a part of the day they are clear, another part of the day they are not. And so there's some instances people come into our office, it's obvious they don't even know where they're at. In some, cases where they do, well, then that's another issue. So, yeah, there's no it's this kind of gut feel a lot. For us, I'm not a medical professional, so for me, it's just, do I feel comfortable doing this? Do I think the person knows who they are, what they've got, and who they want to make decisions for them?
So there's not a legal definition of that, other than what you just described?
There's a lot of cases around that, but just in general, that's it. Do they know who they are, what they've got, and who they wanted to make decisions for them, or if it was disposing of assets like a will, who they wanted to get their assets at their death. Anyone else? Good question. Dr. New?
I think one of the things that's most challenging is when mother is clear enough to know her name and she doesn't remember who you are, or she doesn't want you to take away the card, doesn't want you to take charge of the medication and lock them up. That's when you get a lot of the resistance that Sheila gave in the case study early on. I think that's where it's very challenging for us as healthcare providers. At what point do we go ahead and do those things and recommend those things? It's very, very painful to do that within a family. You get a lot of conflict surrounding that too.
Okay, on the private living will, you don't appoint a person. Arkansas law just says the attending physician. A healthcare power of attorney, you appoint someone as your attorney, in fact, to make healthcare decisions for you. And usually we appoint someone, and if they're not able or willing to, then someone else. So, maybe child number one, if they're not able or willing, or maybe they moved or out of state or whatever at the time, then it's number two. And you mentioned whoever named all of these things, I think, did a poor job. There's living wills and then there's last will and testament. People get those mixed up all the time. A last will and testament says who gets your stuff when you die. It's referred to just as a will. And then living will is what I refer to as a pull the plug document. It says if I'm terminal or irreversible or permanently unconscious, then what happens? And so it's just important that you think about these things in advance and say who you want to make these decisions for you. Yes, two people can serve in that capacity. I don't recommend it personally. I mean, it's just two people could serve as a property power of attorney when you're talking about finances, usually without problem. They may argue, but that's okay. Or two people could be executor of a will or trustee of a trust. But for healthcare power of attorney, if you require two people and you're in town and your brother's, in Alaska fly fishing on a fly fishing trip for 3 weeks, and it requires both of you, then there's a problem. So, or what if you say yes and he says no? There's a problem. So y'all can argue about money, forever, but when it comes to healthcare decisions, just practically speaking, it's better if you have one first. If they can't do it, then the other would be a backup. But yes, two can serve together if that's your wishes. For Medicaid purposes, if you go to a nursing home, there is a 5-year look-back rule. And they can look back 5 years to see if assets were transferred to anyone prior to that time. And so if a typical trust like most people have would be a revocable living trust, which means the assets are fully available to you, and they're always available to you. So if you have one of those, even if you did it 10 years ago, if you go to the nursing home today, those assets are still available to you, and they'd have to be spent down before you would qualify for Medicaid. If you did an irrevocable trust or gave assets to your kids, and say you did it 5 years and 1 day ago, and the trust was done properly, and the assets are not available to you, then the state can only look back 5 years to see what transfers were made. And then if you applied for Medicaid to pay for your long-term care, the assets that you gave away or put in an irrevocable trust more than 5 years ago would not be available to you and wouldn't be considered in your qualification for Medicaid eligibility. I don't know if that hit it or not, but did that answer your question?
Yes, that helps a lot. Thank you.
Okay.
Thank you. Okay.
Oh, okay, we also have one other question.
Stay here. Mr. Jones.
Yes, ma'am.
Does the living will have to pull the plug, or can it say keep me alive? Can it go either
Does a
way?
living will have to pull the plug, or can it maintain life on a ventilator longer, for instance?
You know, I've never had one to do that, but yes, always tell people, just write down what you want. If you want to be hooked up forever and ever, you know, may not happen, but write it down. At least your intentions will be known. And if you don't write it down, then it's just going to be whatever. So you need to write down what you want and get it witnessed and notarized.